record for the 11th and the 12th respondents. Thank you.
Your Lordships, Your Ladyships, President of the Court, my name is Modoni Nyuguto. I do appear with Senior Counsel Mother Karua for the 74th, 75th, and 76th respondents.
My lady, my name is Ochiel Dudley. I appear for Professor Jack Mimali, the 77th respondent, and I hold it for Ms. Kitu from Muhuri, the 24th respondent. I appear alongside Mr. Ray Odanga and Ms. Chitagwa Mwavishi. Most obliged.
Good morning, the Chief Justice of the Republic of Kenya and Lord Justices. My name is Owor Jerry. I appear alongside my colleague, Justice Mutunga, and Dr. Clarence Seboso for the 10th respondent.
Thank you. I believe that is all about the appearances. I will also like to say after we finish reading, we will also issue a media summary of the judgment. So I'll begin my judgment. On 27th August 2010, in what may be fittingly depicted as a symbol of national rebirth and renewal, Kenya promulgated a new constitution, which has been described world over as progressive. This moment marked a historic transition from the old order to a new one. The 2010 Constitution represents the people's aspirations laid out in the text of its preamble, articles, and schedules. It is a framework for the realization of a shared vision and common agenda. It spells out far-reaching fundamental institutional and other reforms meant to sustain human rights, equality, freedom, democracy, social justice, and the rule of law for the present and the future generations. The history behind making of the Constitution cannot be buried and forgotten as it continues to reverberate as the debates and discussions around this amendment acts back to the process and sacrifices that were made by the Kenyan people over many decades during the search for a new constitutional order. Indeed, the preamble there to reminds us of honoring those who heroically struggled to bring freedom and justice to our land. It is the attempt to amend the Constitution as proposed in a document dubbed Constitution of Kenya Amendment Bill 2020, which ran to the instant appeals before this court. The amendment bill is at the core of the dispute that has engaged all the superior courts on the question of interpretation and application with regard to not only the provisions of Chapter 16 that provides for amendment of the Constitution, but the entire body thereto, as the canons of interpretation provided under Article 259(3) enjoins the court to inter alia consider, and I quote, every provision of this Constitution shall be construed according to the doctrine of interpretation, that the law is always speaking, end of quote. This means that the Constitution is always speaking to the present and the future generations. Therefore, in discharging their interpretive mandates within framework of a legal dispute before them, courts are required to uphold the Constitution by breathing life to all the provisions whilst promoting the dreams and aspirations of the Kenyan people in a manner that is consistent with the Constitution. In addition, it is envisaged that the approach to interpretation adopted by a court should not render any article or any provisions of the Constitution superfluous or ineffective. Consequently, as the apex court in the land and custodian of the Constitution, it is not lost to this court that we are being called upon to provide an impartial and authoritative determination which will guide and act as an interpretive compass to the courts below, to the state agencies, and to all the persons with respect to the questions before them. Before delving into the mandate under Article 163(4)(a) of the Constitution, as invoked by the appellants, it is instructive that we should place these appeals in the context by setting out very briefly the background. It is no secret that in striving to promote and strengthen our democracy, a number of attempts have been made to amend the Constitution. Of significance is that there have been a total of 3 attempts to amend the Constitution by way of popular initiative under Article 257 of the Constitution. These attempts were Constitution of Kenya Amendment 2010, Amendment Bill 2015, dubbed the Okoa Kenya Initiative, Punguza Mizigo Constitution of Kenya Bill 2019, and more recently, this particular amendment bill that has brought these appeals before us. The first 2 initiatives failed for not garnering the requisite support at various stages of the amendment process, while the amendment bill was subject to the court process, culminating in the instant appeals. Besides the above 3 attempts under the popular initiative, there have been more than a dozen other unsuccessful attempts to amend various articles of the Constitution since 2011 through parliamentary initiative route under Article 256. The instant appeals concern the amendment bill, whose genesis can be traced to the outcome of the 2017 presidential elections. Following the initial and repeat presidential elections in 2017, His Excellency Honorable Uhuru Kenyatta, the President and Commander-in-Chief of the Kenya Defense Forces, embarked on uniting a divided nation, which led to the reconciliation, famously known as the handshake, between Honorable Raila Odinga, the then leader of the opposition coalition, and himself on 9th March 2018. In line with their mutual commitment to create and foster a united Kenya, the President and Honorable Raila Odinga released a joint communique known as Building Bridges to a New Kenya Nation, highlighting 9 problem areas which they deemed as negatively impacting on the peace and unity in the nation. Subsequently, the President established the Building Bridges to Unity Advisory Task Force, BBI Task Force, via the Gazette notice dated 24th May 2018. Its mandate was to evaluate the 9 identified problematic areas and make policy, administrative, and reform proposals that would build lasting unity based on consultation with citizens. Towards that end, on 26 November 2019, the BBI Task Force presented its reports titled Building Bridges to a United Kenya, from a nation of blood ties to a nation of ideals. That report was presented to the President and the Honorable Raila Odinga, which was unveiled to the public the following day on 27th November 2019. Intent on the implementation of the proposals in the BBI Task Force report, the President appointed the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report, via a Gazette notice dated 3rd January 2020. The main objectives of the BBI BBI Steering Committee was to undertake validation of the task force reports with citizens, as well as propose administrative, policy, statutory, or constitutional changes it thought necessary for the implementation of the recommendations contained therein. On completing its mandate, the BBI Steering Committee presented its report, titled The Report of the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force Report. This was done on 21st October 2020. Annexed to the report were a number of documents, including a draft Constitution of Kenya Amendment Bill 2020 and the proposed legislative amendment bills. Somewhere along the line, the draft Constitution of Kenya Amendment Bill 2020 was reviewed, culminating in the amendment bill, which was published by the government printer about a month later on 25th November 2020. Thereafter, the BBI, to a United Kenya National Secretariat, put in motion the process of correcting signatures in support of the amendment bill. Upon correction of the requisite number of signatures, the BBI National Secretariat submitted the same, together with the amendment bill, to the Independent Electoral and Boundaries Commission for verification and thereafter, and this is what brought the litigation. While the amendment process was ongoing, 8 petitions were filed before the High Court, challenging the constitutionality of the process, which resulted in the amendment bill and the contents thereof. 7 petitions were consolidated on 21st January 2021, while the 8th was consolidated with the rest on 10th March 2021. Kenya Human Rights Commission and 4 of professors, Duncan Ojuang, Osogo Amani, Dr. Rinda Musumba, Jackie Mwimari, were joined as amici curiae, while Kituo Cha Sheria and Filista Wakesho were also joined as interested parties. Most of the petitions raised more or less similar issues, which are summarized in our judgment. We have summarized what is contained in petition number E282 of 2020, David D. and others versus the Attorney General. We have also summarized the petition by the Kenya National Union of Nurses, the petition by the Third Alliance, Kenya versus the Steering Committee of the BBI, in opposition to those petitions that were filed, the competency of the petition was challenged by the Attorney General, who argued that the issues raised therein were res judicata or sub judice. After hearing the matter, the High Court identified issues for determination, which they duly did, and came up with a judgment which was appealed before the Court of Appeal. Before the Court of Appeal, IBC filed 12 grounds of appeal challenging the High Court's findings, contending that the court had, by finding there was no quorum to undertake the constitutional and statutory mandates. It is also challenged the decision that the court misapprehended the provisions of Article 257(4), which did not require the IBC to verify whether there was public participation before the verification exercise. in the High Court, this appeal was challenged. The Court of Appeal had the appeal and also the cross appeal by the Kenya Union of Nurses and also by OP 254 and the cross appeal by Mr. Morara Omoke. In determining those appeals, the court framed 21 issues which were determined by the conclusions and findings that were pronounced in the read judgment by Musinga J. Those findings are there, I need not read them. And before us now, the Attorney General, the IBC, and the third appellant were dissatisfied, and therefore they found these appeals, which were consolidated before us, and we were able to frame 7 issues for our determinations. We also directed parties to file written submissions, which were done, and we have summarized all those submissions in our own judgment. I do not wish to read what each party said in the argument to support the appeal. The appeals were also opposed by the respondents, and we have captured all the submissions in opposition in the judgment. There were parties also who supported the attorney and the 15 respondents. We have captured what they said. The National Secretariat and the Honorable Raila Amolo Odinga. The appeal was also supported by the President, and we have captured what was submitted before us by Council in our long judgment. The 19th respondent, Isaac Arwoche, appeared in person, relying on his submissions, which we have also highlighted in our own judgment. The 72nd respondent, Pirista Wakesho, we have also captured what was said in the submissions. We have highlighted the specific parties who opposed the appeals. Mr. Morara Omoke opposed the appeal, supporting the decision of the High Court. The first, second, third, fourth, and fifth respondents represented by Mr. Nelson Harvey and Ms. Esther Angawa also opposed the appeal and relied on their written submissions and made oral submissions, which we have captured in our own judgment. The 7th, 8th, and 9th respondents are represented by Mr. Elias Mutuma, appearing with Ms. Gerono for the 7th to the 8th respondents, also relied on their joint submissions and made oral highlights, which we have captured in great detail in this judgment. The 11th and 12th respondents, represented by Learned Counsel Mr. Elisha Ongoya and Evans Oganda, made submissions in opposition to the appeal. So was Mohori, represented by Ms. Caroline Kituku, made extensive submissions on the issue of the verification of signatures by IEBC and also the quorum of IEBC. We have captured that. The 79th respondent, Kituo Sasheria, represented by Learned Counsel Dr. Kaminwa, also made extensive submissions, and we also have considered the briefs by the Hamisi, Professor Rosalind Dixon, and Professor David E. Randau, the first and second Hamisi. We have also considered Gautam Bhatia, the third Hamisi, and what he told us in his written submissions on the application of the basic structure. Professor Migai Akich, the fourth amicus, also submitted a submissive brief, which we have summarized on the issues that they raised. Professor Richard Albert, the fifth amici, we have captured the submissions regarding the issue of the basic structure doctrine. And Professor Yaniv Rosnai, the sixth amicus curiae. Professor Charles Manga Foband, Professor Dr. Adem Abebe, Dr. Duncan Ojuang, John Osogo, and Dr. Rinda Musumba also filed a very extensive amici brief with Dr. Jack Mwimari. The Kenya Human Rights Commission also made some extensive submissions on the basic structure doctrine. I have considered all those submissions for and against the appeal, and as observed, the appeals are predicated on Article 163, 4A of the Constitution, which grants this court with jurisdiction to determine appeals from the Court of Appeal on question of interpretation and application of the Constitution. Although the length and breadth of the pleadings and arguments are summarized, I've touched on several chapters of the Constitution. The common denominator is that they are focused on the interpretation and application of Chapter 16 of the Constitution, and how that is to be done. The two superior courts below have traversed and touched all the key provisions of the Constitution. In my view, therefore, this court's jurisdiction is properly seized under that provision of the Constitution. And having set out the issues framed by the court for determination, the 7 issues, I will now proceed to deal with them sequentially. On the basic structure, it is pertinent in the circumstances to point out that the basic structure doctrine, as articulated in the High Court and endorsed by the majority judgment of the Court of Appeal, the sum total of the two decisions being that beyond the 3 stipulated pathways for amending the Constitution provided in Chapter 16, there are certain fundamental features in the 18 chapters of the Constitution that are not amendable without first determining on a case-by-case basis whether a proposed amendment forms part of the basic structure. further that any amendment to these particular articles identified as fundamental features of the Constitution would follow a four-sequential process, being civic education, public participation, and collection of views, constituent assembly debates, and a referendum. In effect, the two superior courts below concluded that certain provisions of the Constitution are beyond the reach of enumerated amendment powers stipulated in Chapter 16 of the Constitution. The history of the emergence and evolution of the basic structure doctrine was comprehensively covered in the very detailed judgments of the two courts below. Therefore, I will merely mention some of the key features to place my findings in perspective. The basic structure doctrine first received judicial recognition in 1973 in the Kesavananda case, a decision of the Supreme Court of India. The case concerned a challenge to the state government of Kerala's attempt under two land reform acts to allow state government to acquire privately owned land to fulfill its socio-economic obligations. Subsequently, the Indian Parliament passed the 24th, 25th, and 29th amendments to the Indian Constitution, which in one way or the other shielded Kerala State's land reform acts from being challenged in court. It is in this context that the Supreme Court of India addressed the question of whether there were limits to Parliament's power to amend the Constitution. In a majority judgment of 7 judges with the 6 judges dissenting, the Supreme Court of India held that the 24th, 25th, and 29th Constitutional Amendment Acts passed by Parliament, exercising its powers under Article 368 of the Constitution of India, were unconstitutional to the extent that they damaged the basic structure of the Constitution. The doctrine places substantive limits on the amendment power by placing the basic features of the Constitution beyond the legislative's power to amend the Constitution. In effect, the Supreme Court of India endorsed the idea that a constitutional amendment can be unconstitutional on substantive grounds. I have recited or restated the provisions of Article 368 of the Indian Constitution. And from that provision, it is clear from its reading that the amendment process under the Constitution of India is exclusively vested in the legislature. This therefore means the amendment process of India's Constitution can be described as falling under the flexible model of amendment powers in the flexible regime dichotomy used to categorize the nature of amendment powers in a given constitution. And for this preposition, I have also read the books by Zachary Ekins and Richard Albert on making, breaking, and changing the constitutions. Subsequently, the basic structure doctrine and the idea of limits of power to amend a constitution have been considered by courts in several jurisdictions across the world and received mixed reception. For example, the basic structure doctrine and its various variants have been accepted in Bangladesh, Belize, Colombia, Taiwan, Malaysia, Slovakia, and Peru. While courts in France, Georgia, South Africa, Singapore, Zambia, Uganda, and Tanzania have rejected the doctrine. What this state of play demonstrates, which has been recognized by some of the distinguished scholars as reflected in the various materials cited before us, is that the basic structure doctrine has not yet matured into a universal norm of constitutionalism. And for that, I have referred to the writings by Richard Albert, Maukas, Makize, Antares okay. Given that the basic structure doctrine has not matured into universal norm of constitutionalism or a doctrine of general application, courts have adopted the approach of evaluating its fit within their constitutional systems before accepting its applicability in the various jurisdictions where it has been considered. In Kenyan context, this court has already developed an approach which courts are obligated to follow in ascertaining whether to transplant any juridical idea to the Kenyan Constitution in the post-2010 constitutional order. In the vetting board case, this court grappled with the question of the scope and effect of the ouster of the judicial review power of the High Court by a constitutional ouster clause. Whereas the court considered similar jurisprudence on ouster clauses from other Commonwealth countries that had been inspired by the landmark decision of the House of Lords in the animistic case versus Foreign Compensation Commissions and ANA. This court developed the interpretive model to be followed. In that case, the vetting board. I have considered the dictum in that case and the imposed obligation by this court under Section 3C of the Supreme Court Act, which provides that we must develop rich jurisprudence that respects Kenya's history and traditions and facilitates its socio, economic, and political growth. Accordingly, before declaring the applicability or otherwise of the basic structure doctrine in Kenya's constitutional context, a court is obligated to take into account our constitutional history, especially bearing in mind that the doctrine, which found root in 1973 in India, was available when the framers of the Constitution of Kenya conceptualized the provisions of Chapter 16 on amendments. Another way of looking at the matter is to ask a pertinent question as to whether there are gaps identified in particular in regard to the provisions of Chapter 16 of the Constitution requiring to be sealed by the basic structure doctrine. In addition, in evaluating whether the basic structure doctrine is applicable in our constitutional system, a court must take into account the purposive and value-based interpretation decreed by Articles 10, 20, 4, 159, and 259(1) of the Constitution. Such an approach to constitutional interpretation begins from and remains rooted in the text of the Constitution, whilst interpreting it holistically, giving effect to its values and principles, and never losing sight of the historical context and the backdrop of the provisions being interpreted. Therefore, to comprehend and contextualize whether the Constitution contemplates the basic structure doctrine, the starting point should be the rationale behind the provisions of Chapter 16 as documented in the preparatory documents from the constitution-making process. It is an understatement to say that Kenyan independent constitution endured a legacy of hyper amendments during the post-independent period. The former constitution was flexible, giving the legislative wide power and discretion in amending it. As a result, Parliament undertook so many amendments to the Constitution that it lost its original character. The most significant amendments being the merger of the Senate and the House of Representatives to establish a unicameral legislature, abolition of the quasi-federal regional governments that led to the establishment of a unitary state, and alteration of the entrenched majorities required for constitutional amendment, making it easier to amend the Constitution. Yet another repulsive amendment was the abolition of the security of tenure for judges and other constitutional office holders. Ultimately, the amendment that finally broke the proverbial camel's back, giving rise to the clamor for a new constitutional order, was the one that converted the country from a multi-party democracy to a de jure one-party state in 1982. Informed by this history, Kenyans yearned for a stable constitutional system where the power to amend the constitution would not be abused for short-term interests by political elite. The CKERC report records at page 74 that Kenyans express what they wanted, and I quote, "There is a need to protect the Constitution against indiscriminate amendments." What emerges from the historical account is that there was a strong concern that the country should adopt provisions on amendment power that are able to protect the constitutional order from abusive amendments. But this was not all. There was also a recognition that the Constitution must remain flexible in order to adjust to political, social, economic, technological, and other changes that to take place in the polity. In effect, the overarching imperative that informed the drafting of Chapter 16 was the need to find a proper balance between rigidity and flexibility. The quest for a balance between rigidity and flexibility is evident in the tiered amendment provisions in Chapter 16, which stipulates 3 pathways for amending the Constitution. The first pathway, under Article 256, provides for amendment by parliamentary initiative. This process involves public participation and approval by the Houses of Parliament through a vote of endorsement by 2/3 of all members of each House during the second and third reading of the amendment bill. The second pathway, under Article 257, provides for amendment by popular initiative. This process involves collection of at least 1 million signatures from registered voters in support of the popular initiative by the promoters of the initiative. Approval of the initiative by the majority of the county assemblies, and passage of the bill by the majority of the members of each House of Parliament. In this second process, if either House of Parliament fails to pass the bill, the proposed amendment is submitted to the people in a referendum. The third pathway, under Article 255, relates to what has come to be known as the entrenched provisions of the Constitution. Some of the Court of Appeal judges referred to these entrenched provisions as forming the basic structure of the Constitution. Article 255(1) of the Constitution stipulates that in addition to adopting either the parliamentary initiative or popular initiative pathway, where an amendment relates to the following articles, a bill to amend those provisions shall be subjected to a referendum. These are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the national values and principles of governance in Article 10(2), the Bill of Rights, the term of office of the President, the independence of the judiciary and commissions, and independent offices, to which Chapter 15 applies, the functions of Parliament, the objects, principles, and structure of devolved government, or the provisions of Chapter 16 on amendment of the Constitution. Approval through the envisaged referendum under Article 255(2) must satisfy 2 conditions. At least 25% of the registered voters in each of at least a half of the counties should vote in the referendum, and such an amendment should be supported by a simple majority of the citizens. A reading of the 3 pathways for amending the Constitution in Chapter 16 clearly shows that Kenyans were alive to the historical legacy of the culture of hyper amendment in the pre-2010 era and sought to tame any abuse of the amendment power. In particular, Article 255(1) and 2 of the Constitution demonstrates that, alive to the culture of hyper amendments, the Kenyan people sought to ring-fence the core fundamental commitments of the Constitution by entrenching them and subjecting the process of amendment to deepen public participation, as well as imposing a downstream constrained veto by stipulating that the entrenched provisions enumerated in Article 255(1) of the Constitution can only be amended through a referendum process. The rationale of entrenching the provisions mentioned in Article 255(1) of the Constitution is, in my view, informed by the very democratic idea that constitutional amendments of a fundamental nature should take place through a deeply participatory process and be ratified by the people, being the ultimate sovereign of the polity, through a referendum. The approach in balancing flexibility and rigidity in constitutional amendment adopted in Chapter 16 reflects and compares favorably with modern constitutional architecture and design. Drafters of contemporary constitutions pursue the goal of balancing rigidity and flexibility through what has been termed as tiered design amendment rules. This argument is augmented by the articles cited before us by Professor Rosalind Dixon and David Randau in their writing titled Tiered Constitutional Design. Under the tiered constitutional model, amendment rules vary with provisions that are core to fundamental to constitutional systems being placed on a higher tier and made more difficult to amend. The amendment rules under the Constitution adopt this modern tiered constitutional design, combining the virtues of rigidity and flexibility by having different amendment procedures apply to different parts of the Constitution. The core foundational values, principles, and structures of the Constitution have been granted a higher level of entrenchment to ensure the stability of the constitutional system. It follows, therefore, that Kenyans were conscious of the core constitutional values, principles, and structures that they wanted protected from abusive amendments, and they protected them through entrenched provisions in Article 255 of the Constitution. In my view, therefore, the framers of the Constitution, well aware of the basic structure doctrine, chose to ring-fence some key features from flexible amendments. And if it was their intention to provide for eternity clauses or the basic structure doctrine, nothing would have stopped them from doing so. The next question that follows is whether it was necessary for the two superior courts to adopt the basic structure doctrine and thereby devise a four-way path for amending the Constitution outside the three pathways that are stipulated in Chapter 16. To answer this question requires one to appreciate how the High Court and the majority of the Court of Appeal judges proceeded to analyze Chapter 16. It was on the premise that, based on the history of hyper amendments of the repealed Constitution during the pre-2010 dispensation, the Constitution demanded heightened procedures beyond the tiered design of the amendment procedures provided in Chapter 16 that would make the Constitution more difficult to amend. The two courts, therefore, did not go into a detailed analysis and to specifically point out the actual shortcomings of the provisions of Chapter 16, especially in light of all the 21 unsuccessful attempts that have been made over time, over the last 10 years, to amend the Constitution. The Court of Appeal, in my respectful view, and a duty to analyze the findings of the High Court and specifically point out whether there were apparent inadequacies as far as the provisions of Chapter 16 were concerned. Looking at the history, as stated above, as well as the provisions of Chapter 16, it is clear to me that Kenyans sought to achieve a balance between rigidity and flexibility in the amendment process. Kenyans did not want to shift from one extreme of hyper amendment to another extreme where no amendment can take place. That is, from hyper amendment to ultra rigidity in the amendment process. Rather, what Kenyans desired is a balance between rigidity and flexibility, as reflected in the tiered amendment process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened protection, but still open to amendment through an enhanced, inclusive, and participatory process that culminates in our people exercising their sovereign power through ratification in a democratic process in the form of a referendum. The High Court and the majority of the Court of Appeal, with tremendous respect, failed to appreciate that the tiered amendment process is one of the options available in the menu of constitutional designs options for dealing with the practice of abusive amendments, just like other designs options limit amendability. For example, eternity clauses and basic structure doctrine. Therefore, where Kenyans have selected the tiered amendment procedure as their response to the culture of hyper-amendability, I find it difficult to justify this judicially created fourth pathway of amending the Constitution founded on the basic structure doctrine. Unfortunately, there was no justification provided to demonstrate the lacuna in the Constitution, and hence the need to call in hand the basic structure doctrine to enhance the existing tools of interpretation. The 2010 history of Kenya is replete with precedents of application of foreign laws and doctrines from Commonwealth and other jurisdictions, which was done due to absence of local statutes. Today, I dare say that courtesy of our Constitution, we have sufficient arsenals that include our own canons of interpretation, which we must exhaust before borrowing from other jurisdictions. Further, I see a potential conflict within the constitutional system with a judicially created fourth pathway for amending the Constitution. This is for the simple reason that in our constitutional dispensation that is people-centered, our nascent democracy that respects the doctrine of separation of powers by vesting legislative power in the legislature, to create a fourth pathway within the scheme of amendments would bring into question the place of the participation of the people and the place of the legislature in that scheme. Taking into account where we are at in our constitutional democracy, Kenyans needed to be consulted on whether it is their wish to introduce the fourth pathway for amending the Constitution. In other words, we judges should be vigilant, lest we are accused of usurping the sovereign power vested in the people by introducing a constitutional amendment through judicial fiat. Put differently, the tiered amendment process provided in Chapter 16 of the Constitution is a design option for dealing with the problem of abusive amendments and obviates the need for judicially created limits to amendments power like the basic structure doctrine. This is in line with the view expressed by Professor Rosaline Dixon and David Randau. My take home from this scholarly perspective is that tiered design of constitutional amendment process is one of the design options used to curbing the problem of hyper-amendments. Professor Rosanai rightly points out in his well-balanced amicus brief that the applicability of the basic structure doctrine depends very much on the context. The most important contextual consideration is the balance between flexibility and rigidity of the amendment process. The more difficult the amendment process, the less there is need for a doctrine of implied limits to amendment power. The jurisprudential underpinning of this view is that in a case where the amendment process is multi-stage, involves multiple institutions, is time-consuming, engenders inclusivity and participation by the people in deliberations over the merits of the proposed amendments, and as downstream veto by the people in the form of referendum, there is no need for judicially created implied limitations to amendments power through importation of the basic structure doctrine into a constitutional system before exhausting homegrown mechanisms. Moreover, I fully agree with a portion of the judgment by Sishare J, where she questioned the viability of relying on judges to interpret on case-by-case basis on whether a particular provision of the Constitution is amendable. To put this into perspective with respect to our constitutional architecture, amendment of entrenched provisions of the Constitution relating to the matters listed in Article 255(1) through popular initiative route requires, first, there must be public participation throughout the amendment process by dint of Article 10(2) of the Constitution. Second, collection of 1 million signatures from registered voters in support of the initiatives as provided in Article 257. Third, support of the initiative through approval of the bill by a majority of the county assemblies as stipulated in Article 257(7). Fourth, consideration of the bill by the bicameral House of Parliament, Article 257(10). Fifth, subjection of the bill to a referendum in terms of Article 255, in which at least 25% of the registered voters in each of at least half of the county's votes in the referendum, and the amendment is supported by a simple majority of the citizens voting in the referendum. Six, it should also be appreciated that the processing of the bill in the county assemblies and the bicameral houses of parliament is also subject to a further public participation requirement in terms of Article 196 and 118 respectively. Seventh, Article 88(4)(g) imposes an obligation on voter education on IEBC. Amendment of the entrenched provisions under parliamentary initiative routes by dint of Article 10(2) of the Constitution requires public participation, which must inform the entire amendment process. Second, the amendment bill has to go through the bicameral House. Looking at the two pathways for amending the entrenched provisions, it is inescapable to conclude that amending the core of fundamental provisions of the Constitution is a multi-staged, multi-institutional, time-consuming process that ensures that a constitutional amendment process that touches on the core of the fundamental aspects of the Constitution is transparent, inclusive, engenders the participation of the people, in a democratic society where they decide their own governance. I therefore find that the tiered amendment process under the Constitution meets the set criteria as to when judicially created basic structure doctrine is inappropriate and undesirable. Therefore, the two courts below and by finding a fourth judicially created pathway for amending the Constitution, which is with respect tantamount to amending the Constitution through the judgment of the court. To buttress the point of tiered amendments post-2010 Constitution, the amendment practice post-2010 Kenya illustrates that the tiered amendment design is an adequate work against abusive amendments. As pointed out by Sishare J in a dissenting opinion at the Court of Appeal, there have been 21 failed attempts to amend the 2010 Constitution during the first decade of its operation. 19 of these were through the parliamentary initiative and 2 were through the popular route. It is also notable that although the amendment bill had gone the farthest in amendment process, it was yet to be subjected to the ultimate downstream veto of the referendum process. Comparatively, the Independence Constitution had undergone 12 major amendments by its 10th birthday. In essence, it is right to conclude that the resilience of the 2010 Constitution in its first decade is proof that Kenyans attained the goal of balancing flexibility with rigidity in designing the amendment power as reflected in Chapter 16 of the Constitution. It ought also to be appreciated that judicial protection of implied limitation to the amendment power, such as through the basic structure doctrine, become increasingly required in context where the country has 2 flexible constitutions that can be amended fairly easily. Therefore, while it was inappropriate in the pre-2010 dispensation for the High Court, Lingera J, as it then was in the Joya case, to recognize the basic structure doctrine under the repealed Constitution, there is no such need under the 2010 Constitution. This view is founded on the premise that the risk of abusive amendments has been tamed by the tiered amendment process that entrenches the core of essential provisions through a heightened, elaborate amendment process. Considering the progressive nature of the Constitution, a 3-judge bench, Korir, Goge, and Odunga in Priscilla Dururu case, expressed skepticism as to the continued relevance of owning the Joya case on the basic structure post-2010 Constitution in light of the provisions of Article 255 of the Constitution. In contrast, the unique context of India, with a 2 flexible constitution that grants the legislature the wide discretion in amending the Constitution, arguably justifies the judge-made basic structure as developed and practiced in India in order to stabilize the constitutional order and prevent the practice of abusive constitutional amendments, given the low threshold for amendments in the text of the Constitution, just as it was in our case prior to the 2010 Constitution. Although I think I've said enough to demonstrate why I disagree with the judgments of the majority of the Court of Appeal bench regarding the application of the basic structure post-2010 Constitutional order, I will briefly highlight some of the critical aspects which were not considered by the 2 superior courts, and if the judges had done so, perhaps they would have come to a different opinion. Number 1, the superior courts failed to appreciate that the concern with the culture of IPA amendment had already been taken into account during the drafting of the Constitution of Kenya 2010. This led to the design of the tiered amendment process that balances flexibility and rigidity. In such a context, the correct judicial posture ought to have been fidelity to our Constitution. This is informed by the reality that the Constitution, to a large extent, is self-contained and self-regulating in dealing with the legacy of abusive amendments in the former constitutional amendments. Therefore, there is no justification for courts to go outside the 4 corners of the Constitution to create a 4th pathway for the amendment of the Constitution. Number 2, the Court of Appeal failed to analyze the provisions of Chapter 16 and to arrive to its own independent conclusion on the shortcomings of the 3-tiered process, and to state clearly whether it was necessary to call in aid a foreign doctrine also to take into account the amendment practice in the post-2010 dispensation in the analysis of the Kenya's constitutional history, which shows that Chapter 16 of the Constitution has brought stability in the constitutional system in contrast to the culture of hyper amendment under the former Constitution. There have been multiple attempts to amend the Constitution, which were all unsuccessful, meaning that the amendment process is not flexible, as in the Indian case. 3, the Court of Appeal failed to take into account the fact that Chapter 16 is one of the entrenched parts of the Constitution under Article 255(1) of the Constitution. Therefore, it could not be amended by the court through created fourth pathway of amending the Constitution without following the constitutionally ordained amendment process provided for under Article 255(1) of the Constitution. And fourth, the Court of Appeal failed to appreciate that Kenyans were aware of the idea around the basic structure doctrine during the Constitution making phase in light of the legacy of the case of Joya, and yet did not embrace the idea of a veto to the amendment power as represented in the basic structure doctrine, as well as related to doctrines like eternity clauses. The CKERC report on page 76 indicates that Kenyans yearned for power to have a say in amending the core fundamental features of the Constitution through a referendum and an inclusive and participatory process. This was done through the provisions of Article 255 of the Constitution. Another aspect of the majority judgment of the court that I need to address relates to how the two courts treated the historical background informing the drafting of Chapter 16. It is evident that the decision on the question of the application of the basic structure doctrine within Kenya's constitutional system was largely turned on historical inquiry to clarify and provide interpretive guideline on the intent of the Kenyan people during the drafting of the Chapter 16. While this court has in the past celebrated the virtues and utility of the historical context, the background to the adoption of the Constitution in the Constitution interpretation is imperative. Given the subjective nature of the historical narratives, courts should endeavor to extract and have a view of the complete account of the historical background to the constitutional provision being interpreted. Where a court embraces an account of history that marginalizes, excludes, or suppresses or omits some portions of history account, such an incomplete history distorts or rather fails to illuminate the meaning of the constitutional provision being interpreted, hence misleading the court to reach an erroneous conclusion. Before leaving this part, I will also address the argument advanced by Dr. Kaminwa that the basic structure doctrine is applicable in Kenya pursuant to the provisions of Article 2.5 of the Constitution. The provision reads, and I quote, "The general rules of international law shall form part of the law of Kenya." This court has already provided juridical interpretation of Article 2.5 in the case of Mitubel, where it was held, and I quote, "In light of the foregoing, we hold that the once general rules of international law in Article 2.5 of the Constitution refer to customary international norms, including jus cogens. There is a general acceptance that customary international law requires, in the ones of Article 38(1)(b) of the Statute of International Court of Justice, a general practice accepted as law. That is both sufficiently widespread and consistent practice, and what states have accepted as law, opinio juris, accompanying it. Examples of customary international law include the doctrine of non-refoulement of refugees and granting of immunity for visiting ends of states. Since the basic structure doctrine is a constitutional law principle acceptable in just a number of states and not an international law principle, it does not amount to a customary international law principle. Therefore, Article 2.5 of the Constitution cannot be the basis for founding the applicability of the basic structure doctrine. In the end, I find that the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the High Court and the majority of the Court of Appeal are not applicable in Kenya under the Constitution. Any amendment to the Constitution must be carried out in strict conformity with the normative standards and provisions of Chapter 16 of the Constitution. I will now move to the second issue, whether the President can initiate amendments to the Constitution through a popular initiative. The question raised was whether the President could initiate the amendment and popular initiative routes provided for under Article 257 of the Constitution. Like other norm-producing process, a constitution amendment process starts with an initial decision. That is the initiation or activation of the process. The initiative speaks to how the amendment process starts. The story starts with the 8th August 2017 presidential elections, in which the President was declared by IEBC as having been duly re-elected for a second term in office. The election results were challenged before the Supreme Court by Right Honorable Raila Odinga, who had been declared as the runner-up to the presidential elections. The Supreme Court annulled the results through a majority decision delivered on 1st September 2017 and ordered fresh presidential election to be conducted within 60 days of the nullification. However, the Right Honorable Raila Odinga and his political coalition, the National Super Alliance, withdrew from participating in the fresh presidential election, which took place on the 26th October 2017. Subsequently, Right Honorable Raila Odinga and the NASA coalition vowed not to recognize the government that was formed as a result of the fresh presidential election. This led to some incidents of violence that brought about tension in the country. After months of tension, the President and the Right Honorable Raila Odinga, in an act of statesmanship, patriotism, and bipartisan accord, emerged on 9th March 2018 to announce to the public that there was cessation of hostilities between the two political sides in what they called a handshake, through a joint communique, building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their report, which was unveiled to the public. On 10 January 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the Building Bridges to Unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution-making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy, and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being non-bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative in light of the overarching right motive of the Constitution, which is concerned with tampering or limiting the powers of the presidency. In its architecture and design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator of a popular initiative is the role of the President with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the President a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the President has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the President ought not to be both a prayer and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255, 3b of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This brings me to the inescapable conclusion that state institutions and state organs, such as the presidency, cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the President and even the Attorney General sustained an argument that barring the President from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the President's political rights as protected for in Article 38(1) of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution. However, there is an additional handle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the rights of the fundamental freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38(1) grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizenship qualification, the freedom to make political choices is a right that does not accrue to state organs or institutions. State organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the President, when acting in his private capacity as a citizen, can enjoy freedom to make political choices, this right does not accrue to the institution of the presidency, which is a state organ. The presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of presidency and other state institutions from initiation of a process to amend the Constitution through the popular initiative route does not violate the political rights protected under Article 38(1) of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by the President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President, by a number of antecedent acts, and initiated the process, and the state was the real force behind the amendment process, including through the use of state resources to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat through Honorable Dennis Wawero and Honorable Junet Mohammed who are the initiators and promoters of the impugned constitutional amendment initiative and not the President. An examination of the evidence before the courts revealed a number of things relevant to this factual determination. For starters, the President and the National Executive took certain actions which portray its law in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off the communique in March 2018. The official title of the President. The communique was published in a paper bearing the coat of arms of the Republic and the seal of the President. The President appointed the BBI Task Force and the BBI Steering Committee Task Force through Gazette Notice of 51, 54, and 264 of 2018, respectively. The President received the official reports through a state function as President. As a result, it cannot be disputed that the President was involved in the initiation of the amendment bill. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat, who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my finding that the genesis of the amendment bill can be traced to all these actions. I therefore affirm the factual findings by the two superior courts that the President was involved in the amendment bill and agree with the finding by Tuyot J. I believe I have stated enough to support my conclusion that the President of the state institutions are not permitted to initiate or promote a constitutional amendment process through the popular initiative route envisaged in Article 257 of the Constitution. This now takes me to the third issue, whether the second schedule to the amendment bill was constitutional. To put this question in context, it ought to be appreciated that the second schedule was intended to serve as a transitional scheme of implementing Clause 10 of the amendment bill. Clause 10, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with the words 360. Clause 1(2) of the second schedule proceeded to distribute the additional 70 constituencies as per the schedule. It is in the above context that the constitutionality of the second schedule, directly allocating and apportioning the proposed constituencies to specified counties, was challenged. The two superior courts were unanimous in their findings that the second schedule to the amendment bill was unconstitutional. This finding was based on the substantive grounds that the second schedule violated the basic structure of the Constitution by purporting to take away the mandate of the IBC, an independent body under the Constitution. Further, it was contended that the second schedule impermissibly directed IMBC on the execution of its constitutional functions. It is imperative to begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure and doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was public participation in coming up with the second schedule. This is because the provisions of Article 89 are amendable as long as due process is followed. It ought to be appreciated that amendments touching on matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. It should be noted that directly allocating and apportioning constituencies usurps the mandate of IBC, an independent constitution commission, removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary. The centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor. Much more so because malapportioned constituencies have the potential of diluting the power of the votes, hence threatening the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4.2 and 10.2a of the Constitution. Further, since the constituencies are units of social and economic development through allocation of national government constituency development fund and the recruitment into disciplined forces such as the Kenyan Defence Forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social justice enshrined in Article 10.2b of the Constitution. It goes therefore without saying that the delimitation of constituencies must be accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subjected to public participation and referred to cases by this court, the British American Tobacco case, that provided that there should, the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable notice and opportunity afforded to the public for generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of the process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the people in coming up with the recommendations of the bill that was published on 21st October 2020. There is, however, no evidence of any form of public participation or deliberation between 21st October 2020 and 25th November 2020 when changes to the draft constitution of Kenyan bill was made, including the addition of the second schedule. This leads, therefore, to my conclusion that the constitutional threshold of reasonable public participation was not met when the second schedule of the amendment bill was presented. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10.2 of the Constitution. I move now to the fourth issue on the presidential immunity. At the outset, it is important to point out that given the Court of Appeal held that the President was not served with the petition number E400 of 2020, in the proceedings before the High Court in which this question arose, it was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, as considered in the President's written submissions filed before the High Court, there is a public element in this matter, so this court should clarify and settle the law on the nature and scope of protection of the President from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings usually takes two forms. First, immunity from liability protects officials not from proceedings being undertaken, but from personal liability at the end of the proceedings, which relates to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the court's or tribunal's jurisdiction to hear a matter because the parties against whom the proceedings are undertaken enjoys immunity. Further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation, like extent of actions and other related to other official function, whether done lawfully or done in good faith. The Constitution contemplates immunity of certain officials in the performance of their functions. For example, Article 160, a member of the judiciary; Article 250, a member of the commission; Article 143, criminal proceedings shall not be instituted against the President or a person performing the functions of that office during the tenure. From the structural ending of the above provisions, there are glaring distinctions that illuminate the nature and scope of presidential immunity envisaged under Article 143(2) of the Constitution. Firstly, all the officials set out above enjoy immunity as persons, holder of office or member of a commission, but not their offices, whereas the President enjoys immunity as both the person in the office and the office itself. This is evident from the choice of phraseology used in Article 143 to the effect that the President or the person performing the functions. To make the point clearer, one can contrast the nature of immunity envisaged in Article 143(2) to Article 259 for an holder of an independent office. Consequently, this leads me to the inescapable conclusion that the immunity of the President is unlike that of the other state actors. The President not only enjoys functional immunity like all public officials who perform state duties, which protects them from civil liability for official functions, they further enjoy sovereign immunity as the end of state and the single representation of the sovereignty of the Republic. Indeed, it is only sovereign immunity that can immunize anyone against both proceedings and criminal liability, because any other immunity would be related to official functions and therefore would inherently be a qualified immunity. The two courts below, especially majority opinion of the Court of Appeal, relied on the phrase "in the exercise of their powers under this Constitution." I am conscious that part of the President's role in the performance of their functions is the interpretation of the Constitution as to whether or not it gives them power to perform particular roles. Upon such interpretation, the President either acts or fails to act in the belief that either that power exists or does not exist. It will follow then that if proceedings were to be instituted against the President after the interpretation which is considered to have been wrong interpretation, then such proceedings should fall within the immunity contemplated in Article 143(2), in that it will be within the performance of the President's functions. There is no provision allowing or requiring the President to seek an advisory opinion from the judiciary before exercising their duties or before determining whether they have power to perform any official acts. And in any event, this would generally blur the separation of power. Further, the two superior courts held that the President or the person performing the functions of the President is not above the law and should be amenable to the law if they act against the Constitution. The implication of this finding is far-reaching and therefore calls for a very careful analysis and consideration by this court. It is necessary to state that the Constitution has provided for how the President and the Executive in general can be kept in check through political accountability, with the provision that the President is liable for impeachment under Article 145 of the Constitution. The grounds for impeachment listed under Article 145(1) of the Constitution includes gross violation of the Constitution or any other law, commission of a crime under national or international law, or gross misconduct. This means that there is a clear avenue to check the President's conduct as acknowledged by this court, by the Court of Appeal in the case of Minister for Internal Security and Provincial Administration versus Center for Rights, Education and Awareness. With respect to legal accountability, the protection of the President from legal proceedings under Article 143 does not mean that President's actions or omissions cannot be challenged in court. Anybody or a party aggrieved by the President's actions or failure can initiate proceedings against the Attorney General, whom by virtue of being the legal representative of the government in legal proceedings also represents the President. As such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein a court may issue appropriate remedies. In effect, the findings of the two superior courts and the ramification of rendering Article 143(2) of the Constitution ineffective or superfluous. This is an interpretive path that, in my view, is not open to the courts. An interpretation of the Constitution that resorts to an amendment via a judgment is tantamount to judicial overreach. This brings me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the President during the tenure of the office. I hold that civil proceedings cannot be instituted against the President or a person performing the functions of the President, of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Such proceedings can be instituted against the President via the Attorney General. Issue number 5 on public participation, whether there was public participation. The issue was framed by the court with two components. The first relates to the role of IBC and Article 257(4), whether IBC is under an obligation to ascertain that promoters of a popular initiative have undertaken public participation during the collection of signatures. It is clear to me that there is no direct requirement arising from the provision of Article 257(4) that imposes an obligation on IBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless, the High Court held that IBC was obligated to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation as provided for under Article 10(1) of the Constitution. It is necessary to keep in mind, to keep reminding ourselves that the IBC, being a creature of the Constitution and statute, can only discharge a mandate vested in it explicitly by the law. This is a direction given under Article 10, which identifies the rule of law as the national value and the principle of governance. It follows that IBC, like all other public bodies, cannot by craft or innovation or interpretation extend its power to include ascertaining whether a promoter or a popular initiator has complied with the public participation requirements under the Constitution. Equally, courts should not encourage extension of powers by constitutional or statutory bodies. Such bodies must operate strictly within the four corners of their constitutional and statutory mandates. Given this view, unless there is a statutory framework enacted that confers power on IBC to ascertain whether a promoter has undertaken public participation, the exercise of such a mandate would be a mere overreach. In the upshot, therefore, it is my finding on the first part of the question as framed that there was no obligation on IBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining that the amendment bill had met the constitutional requirements for transmittal to the county assemblies. As regards the second part of the question as framed relates to whether there was public participation in respect to the amendment bill. In determining this question, it ought to be appreciated that while participation of the people has been identified as foundational value and principle of governance under Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. It is against the standards that are set in the case of BAT by this court that I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, it is discernible that there are 4 stages in the amendment process under the popular initiative route. The initiation stage, that is the correction of signatures, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. It is also not lost to me that an onerous requirement that a promoter conducts public participation before presenting signatures for verification at this stage would be unreasonable, because the whole process may be rejected by IBC like it did the 2 popular initiatives dubbed Okoa Kenya and Punguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public bodies, that is the county assemblies, the IBC, the cost of public participation will be borne by citizens or a group of citizens. In such a context, I am of the view that the requirement of public participation during the period proceeding and during the collection of signature under the popular initiative process should not impose onerous requirements on a promoter of the initiative. The second stage, which is the assembly stage, seems to lend itself more to public participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, timeline of 3 months within which county assembly sought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input from the public. The third stage, that is passage through the Houses of Parliament, is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IMBC, have an obligation to facilitate a broad participatory process that includes voter education. It is important to reiterate that the requisite mode, degree, scope, and extent of public participation or sufficiency thereof is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaningful engagement. On the question of whether there was reasonable public participation and the question of burden of proof, Okwengu and Kiagi JJA held the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of performing the same to establish adequate participation. However, Tuyot JA arrived at a slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons or person who appended their signature in the support of the bill were not aware of the amendment bill. The evidence before the court shows there was a reasonable attempt at public participation with respect to the impugned initiative. This view is supported by the evidence of Donis Wawero, co-chairperson of the BBI National Secretariat. In his affidavit sworn on February 2022, which was in response to petition number 416 of 2020 by Murara Omoke. He reports that BBI Task Force Steering Committee and the amendment bill were products of comprehensive consultative public engagement all over the Republic, which process entailed voluntary nationwide public participation. In addition, he annexed to his affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the process as documented on page 2 of the report, which I have reproduced in my judgments. There was no challenge to the contents of the BBI Steering Committee report and the deposition by Dennis Wawero, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. As far as the second schedule of the amendment bill is concerned, as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the steering committee report that took place on 21st October 2020, wherein the draft amendment bill was attached and unveiled to the public. This version did not have the second schedule in question. There is no evidence of public participation between 21st October 2020 and 25th of November 2020, when the amendment bill was published and introduced in the second schedule for the first time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation for public participation in various governance processes, there is no legislative framework regulating how this obligation ought to be implemented. It is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation under the Constitution by enacting laws to actualize constitutional imperatives. In the end, I hold that there was reasonable public participation with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. The above issue was raised in the High Court by petition number 416 of 2020. It was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257(4). As at the time the verification process was undertaken, only 3 commissioners of IEBC were in office, while 4 commissioners had resigned and they had not been replaced. The High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the Court of Appeal bench, with Sishar and J.E.N. dissenting. In light of this background, that this court is called upon to determine whether IEBC was constitutionally infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution. While Article 88 of the Constitution establishes IEBC, provides for eligibility of appointment of its members and its mandate, this provision does not touch on its composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provision regulating its composition. The Article 251 provides as follows, I quote, each commission shall consist of at least 3, but not more than 9 members. Section 5(1) of the IEBC Act, which statute, according to its long title, is an act of parliament to make a provision for the appointment, effective operation of the IEBC, provided that the commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution. Section 5(1) appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5(1) of the IEBC Act being read as imposing different requirements with regard to the composition of IEBC. This leads to the question as to whether IEBC, composed of 3 commissioners, would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5(1) of the IEBC Act should be read in a manner that conforms to Article 251 of the Constitution. The reason being that Article 2, which expresses the supremacy of the Constitution, demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament cannot erode the Constitution. The expressed intention of Parliament in legislation cannot trump the normative command of the Constitution in a legal system where the Constitution is supreme. And this has been emphasized by the decision of these courts in the case of Hassan Jogo and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other courts in other jurisdictions which support this approach to statutory interpretation. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of 3 commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it undertook the verification of the verification process under Article 257 of the Constitution. This now takes me to the last issue. Issue number 7. On this issue, the High Court determined that Article 257(10) of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Okwengu, Kiagi, Katembo, J.A. under the qualifier subject to the nature of the proposed amendments. Musinga J.A. disagreed with the learned judges of the High Court and held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On his part, Tuyot J.A. held that since IBC had not received the requisites and had not discharged its responsibility of framing the questions, the matter was not ripe for determination. The first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. It prevents parties from approaching a court before a party has been subjected to any prejudice or real threat of prejudice as a result of a registration or conduct that is challenged. At the time of filing of the subject petitions, particularly petition E400 of 2020, the amended bill was yet to be subjected to the county assemblies for debate. This means that IBC was yet to be invited to make a determination on the manner and form of the referendum questions, taking into consideration that IBC obligation under Article 257(10) of the Constitution had not arisen. Tuyot J.A. was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 277(10) of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, are number 1, the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. That being the case, the Constitution bill does not pass muster as a popular initiative under the provisions of Article 257 of the Constitution. 3, the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Articles 10(2)(a) and 89(7)(a) of the Constitution. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Issue number 5, there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining the amendment bill. In addition, there was public participation with respect to the amendment bill, save with respect to the second schedule of the impugned bill. Issue number 6, IEBC and the requisite quorum to undertake the verification of signatures in support of the amendment bill and Article 257(4) of the Constitution. 7, I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. And lastly, on cost, this being a public interest matter, I find each party should bear their own costs of this litigation and also the other courts below. That is my judgment. I'll now request the Honorable Justice Ouko to read his judgment.
Thank you, Judge President. This is a summarized version of my judgment. This appeal, consolidating 2 others, marks the first time in the history of the Supreme Court of Kenya to determine the remit of constitutional amendment through a popular initiative and Article 257 of the Constitution. The road traveled by Kenyans since 1991 in search of a new constitution, culminating in the 2010 document, has been sinuous and meandering. A road characterized by violent demonstrations, protests, mass actions, and even loss of life. Like the biblical narrow road which leadeth unto life, it was the way, the only way to a new beginning. And so at 10:26 a.m. on Friday, 27th August 2010, with a single stroke of his pen, President Mwai Kibaki endorsed the draft constitution, and there was a dawn of a new era. Before an ecstatic Kenyan people, and as cannons broke into a 21-gun salute, the President released 2 white doves as a sign of peace, love, hope, marking the birth of the Second Republic. Having emerged from this phase, Kenya embarked on building constitutionalism, giving meaning to the terms and values of the supreme law to which Kenyans must turn to for protection in times of need. It was time for the people to read meaning into its words. It's only through this robust enforcement, application, and interpretation by courageous citizens, lawyers, legislature, executive, and even more so by judges, that the Constitution will be safeguarded to realize the Kenyan dream contained in the preamble. And so, with the difficult history of constitutional making enumerated in the lead judgment of the Honorable the Chief Justice, the question I pose: have the Kenyan people stayed true to the promise in the preamble that we, the people of Kenya, adopt, enact, and give this constitution to ourselves and to our future generations? So there were 7 issues that were framed, the first one being that on basic structure doctrine, and that's the one I now turn to. In the last 50 years, since the Supreme Court of India decided Casavananda case, the name Casavananda has been synonymous with the basic structure doctrine, and although the term basic structure has not been used, has has been used in a few cases in this country in the past. It is during the hearing of this case from the High Court through to this court that it became a household name. I suppose, knowing Kenyans in our true unique sense, there may be children today who are called basic structure, perhaps basic structure George Ochola, just as there may be also in India children born in the 1970s who are given the name Kesavananda after the Hindu spiritual leader who lent his name to the iconic case as the petitioner. Unfortunately, I believe you are all aware, Mr. Kesavananda passed on the 6th September 2020 at the age of 79 years. The origin of basic structure doctrine has largely been attributed to the Indian Supreme Court decision in Kesavananda, with very little or no acknowledgement at all of Professor Conrad's contribution. Yet it is this German scholar who exported it to India. Professor Conrad's theory, which was applied in Kesavananda, postulates that there are implied limits on the power of Parliament to amend certain protected provisions of the Constitution, called the basic structure. Under Article 368 of the Constitution of India, it is Parliament and Parliament alone that is reposed of the power to amend the Constitution. And indeed, clauses 4 and 5 even explicitly limits the power of the courts to review any act of Parliament to amend the Constitution. No amendment of the Constitution made by Parliament pursuant to the provisions of the Constitution can be called in question in any court in India on any ground. However, in construing Article 368 and the limitations on the powers of the court to question the power of Parliament, notwithstanding, the Supreme Court in Kesavananda held that although the article donates exclusive power to Parliament to amend any provision of the Constitution in accordance with the procedure in that article, the powers could not be used to damage, emasculate, destroy, abrogate, change, or alter the basic structure or the framework of the Constitution. The theory was itself influenced by the Germans' political and constitutional history. Under Article 76 of the Germans' original constitution, called the Weimar Constitution, Parliament had the power to amend the Constitution with the procedural restraints that required 2/3 votes of the members of its parliament to pass an amendment. Adolf Hitler, that well-known but reviled figure in history, used this same procedure, a procedure which is anchored in the Constitution, effortlessly to overhaul the entire Weimar Constitution, and arbitrarily took away rights to freedoms of speech, expression, association, and habeas corpus. He then declared the state of emergency. This experience was to inform Germans' constitutional reforms. In their new constitution, the Grand Gazette, the Basic Law, substantive limits have been introduced to the amending power of Parliament. Article 79 of the Basic Law explicitly bars any amendment to the provisions concerning the basic principles like federalism, democracy, rule of law, separation of powers. Our own history is equally replete with the examples and instances that led to agitation for constitutional reforms, as the former constitution was in no better ranking than the Indian or the Weimar constitutions. The former constitution provided for its alteration as opposed to amendment under Section 47 and vested wholly the power to amend it in Parliament, a common denominator with the Indian and the Weimar constitutions. Our Parliament under Section 47, like parliaments of the two nations, could indiscriminately change, and did in fact change, the Constitution at will in any manner whatsoever, without reference to the people. The history of agitation to reverse the trend and save the Constitution, leading to the promulgation of the 2010 Constitution, is well known and are chronicled in detail in my main judgment. But why is this history important? Just like India and Germany, where the seed of basic structure doctrine was planted, it is their unique history that influenced the path of constitutional reforms and the decision of the courts in those jurisdictions in applying the doctrine. Constitutions the world over reflect the uniqueness and specificity of each society, even if lessons or experiences can be drawn from those places. In the Kenyan situation, drawing from the past, informed by the present, and focusing on the future, the 2010 Constitution has set up a framework which returns Kenya to the path of democratization. Parliament cannot be used to pass amendments to the Constitution in the manner it did before 2010 because of the current inbuilt mechanisms and safeguards, as well as the complex and elaborate procedures in the Constitution itself. The situation the Supreme Court of India was addressing in Kesavananda is unique to India, based on the specific provisions of the Indian Constitution, Article 368 to be exact, their experience, and also based on their history generally. Therefore, in relying on Kesavananda, hook, line, and sinker to address the peculiar circumstances of Kenya, the superior courts below ought to have exercised caution and followed the guidelines repeatedly emphasized by this court in various cases, Judges and Magistrates Vetting Board and the Rai case. Courts ought to avoid mechanistic approaches to president because it is inappropriate to pick a president all over the world simply because they appear to provide an answer to a matter at hand. Each of those presidents has its place in the jurisprudence of its own country of origin. There was justification to rely on Kesavananda in interpreting Section 47 of the former Constitution in the Njoya case because at the time our constitutional framework was more or less similar to Article 368 of the Indian Constitution in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitutional making process, from the BAMBA's draft, the WACO draft, the revised harmonized draft, and the proposed draft constitution, it has been made abundantly clear that since the Constitution embodies the will and aspirations of the people, they must be central to its amendment, and that there ought to be a balance to have a Constitution that is flexible enough for posterity and unforeseen needs, but rigid enough to prevent the abusive hyper-amendments of yesteryears. This balance was achieved by clear, unambiguous, and distinct tiered or multi-stage design model, codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendment process of any matters in Article 255(1) is complex and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assemblies and parliament, meeting a certain threshold, and finally ratified in a referendum. Attempts to utilize both parliamentary and popular initiatives have failed essentially because of the tiered or multi-stage design of Chapter 16. You remember the Okoa Kenya Bill 2016, Punguza Mizigo Bill of 2019. To this extent, even the two courts below agree that Article 255(1) embodies the basic structure of the Constitution of Kenya. For me, the most difficult part of the two judgments of the two courts below and the dilemma flowing from them is the imprecise scope and extent of basic structure doctrine. Which provision in the Constitution of Kenya, for instance, are not amendable through the procedure in Chapter 16? What does it mean, for instance, when the High Court and the Court of Appeal accept, on the one hand, that all articles in the Constitution are amendable in accordance with the constitutional procedures provided, but on the other, qualifies the statement by declaring that basic structure of that very Constitution cannot be altered using the amendment power in the Constitution? What does it mean when they declare that the basic structure consists of the preamble, the 18 chapters, the 16 schedules? Is it the Constitution is in entirety as a basic structure? Where do Kenyans who wish to propose amendments to the Constitution go to be shown which provisions cannot be amended using Chapter 16 procedure? Do they go to some deity, some oracle of Delphi, for instance? In interpreting the Constitution, courts must provide pragmatic solutions without adding confusion to the controversy that the parties have brought to them for resolution in the first place. Amending the Constitution is not a light matter, therefore, limitations to its amendment must sufficiently be specific and unambiguous. In India today, because of the nebulous nature of implied limitations to constitutional amendment since Casavananda case, every court has attempted to identify by listing some of the essential structural elements of the Constitution that in their individual perceptions constitute the basic structure of the Indian Constitution on a case-to-case basis. Chapter 16 exhaustively sets out the process of initiating an amendment to the protected provisions. Of course, that process includes public participation and a referendum. That is in answer to the question of where is the juridical basis in the Kenyan context for the proposition by the two courts that the basic structure of the Constitution can only be amended through primary constituent power, which must include four sequential processes, namely civic education, public participation, and collision of views, constituent assembly, a debate, and ultimately a referendum. The last matter under this ground is to consider the unanimous conclusion by both superior courts below that the proposed amendments in the draft bill amounted to dismemberment of the Constitution. Besides the number of articles sought to be amended, the courts were concerned about their overall effect, that they were so far-reaching in character, scope, and content as to, and I quote, shake the foundation and alter the identity and character of the Constitution as to effectively dismember it. The learned judges variously defined the word dismemberment to mean doing any of the following in the Constitution: unmaking, replacing, disassemble, completely change identity, abolish, tear apart, amputate, and rough mutilation. Do the proposals in the amendment draft bill create a new constitution? Do the verbs unmake, replace, disassemble, completely change identity, abolish, tear apart, amputate, employed by the learned judges to describe the proposals in the bill and to suggest that the proposals were a dismemberment of the Constitution, are they so? In my most respectful view, these words were an overkill, and the sledgehammer employed to deal with them was in itself disproportionate. I end this ground where I started. However great, however progressive a written constitution may be, history, experiences, and changes in society would necessitate corresponding changes to the written text of the Constitution, with each generation having the right and freedom to determine the law under which they wish to live. And no generation should bind the course, aspirations, constitutional expectations, values, principles, and objects of generations to come. The language of Chapter 16 is clear and plain, leaving no room for conjecture, inference, or implication. Neither the explicit nor the implicit language of the Constitution, the history of constitutional making, or any principle of constitutional interpretation in this country permits the courts to do what the courts have accused previous parliaments of perpetuating, that is, to undertake indiscriminate and radical amendments to the Constitution by imposing an alien method of amending it. In the result, I would set aside the judgment of the Court of Appeal and hold that to the extent that the basic structure doctrine limits the amendment power contrary to the express terms of Chapter 16 of the Constitution, it does not apply to the Constitution of Kenya, and that there are no four sequential steps for the amendment of the Constitution other than the steps outlined in Chapter 16. The second issue is on the role of the President in the process. This question to me, and of course the question of basic structure doctrine, are the real nerves of this dispute. This particular question seeks to answer the issue of legality, legitimacy, and constitutionality of the process leading to the formulation of the draft bill based on the true construction of Article 257. The High Court was persuaded and declared that the President does not have authority under the Constitution to initiate changes by way of amendment, that a constitutional amendment can only be initiated either by Parliament through parliamentary initiative under Article 256 or by a popular initiative under 257. The Court of Appeal, in a unanimous decision, agreed and affirmed that conclusion. Friday afternoon, March 9th, 2018, which was the same day the justices of the Court of Appeal elected me as their president at Safari Park Hotel, will be remembered as one of the many defining moments in the history of Kenya. It was on that day that, in a move that took many by surprise, the President and his political opponent, Honorable Odinga, with whom he had recently engaged in fiercest and bare-knuckle political contest, met and agreed in what has come to be known as the handshake to end their political rivalry that had been witnessed in the previous elections. The last political contest between the two was so fierce that at the end of it, both laid claim to the presidency. It has been argued that the President and Honorable Odinga, both well-meaning, intended to ease the seething tension and restore peace, unity, and tranquility in the country. To realize this objective and as an understanding of the handshake, the two agreed to pursue a 9-point agenda styled the Building Bridges Initiative, or BBI. A series of events followed, and I traced these events to mark out the role of the President in the process. By a Gazette notice of 31st May 2018, the President appointed a 14-member team known as the Task Force on Building Bridges to United Advisory. By a subsequent Special Gazette notice of 10th January 2020, the Steering Committee on the Implementation of Building Bridges to a United Kenya Task Force report was also established, and as the name suggests, to implement the report of the task force. Of interest, one of its mandate was to propose administrative policy of constitutional changes that may be necessary. The Steering Committee's report was presented to the President on 21st October 2020. It was subsequently launched on 26th October 2020 at BOMAs of Kenya in an event presided over by the President. A third entity, the Building Bridges National Secretariat, whose origin is not clear to me, since I have not been able to trace on record any appointment letter or a gazette notice, appears on the scene. So, co-chaired by Honorable Dennis Waweru, a former member of Parliament for the Dagoretti South constituency, and Honorable Dunet Mohammed, a sitting member of the National Assembly, representing the people of Sonar East. On 25th November 2020, at the Kenyatta International Conference Center, the President launched the draft bill and rolled out the collection of signatures to support the initiative. A popular initiative for amendment of the Constitution according to Article 257 is commenced by the promoters getting at least 1 million registered voters to support it. It is the promoters who must formulate the draft bill. They are required thereafter to deliver the bill and supporting signatures to IBC. And from this point, the process is self-executing along the lines in Chapter 16. The term popular initiative has not been defined in the Constitution, but for the present purpose, the definition sources employed by both the High Court and the Court of Appeal are unanimous that the term popular initiative can only be an initiative by the general public. In common parlance, simply the people. The citizen who was described by Madam Chief Justice in Githunguri as the man in the market, the man on Pangani bus. On the other hand, the word promoters in the Constitution is used only in Article 157. It is apparently a term of art in the context of amendment of the Constitution, describing the persons not in the company law sense or in the colloquial sense, but those who initiate or champion constitutional changes. Beside the definition of the term popular initiative, there is history behind the process for the intendment of the framers. The CKRC final report 2005 acknowledged and recommended that apart from Parliament, it was necessary for the people, in brackets, citizens and civil society, in exercise of their constituent power, to be involved in the constitutional changes. The term popular initiative originated from this report. With that history in mind, there cannot be any debate as to the target of Article 257. It is the people. The suggestion that Honorable Waweru and Honorable Mohammed, as co-chairpersons of the Secretariat and not the President, were the promoters cannot be accurate. First, the Secretariat emerged, as I've said, from the blues, as it were, for the first time in the process. However, Honorable Waweru himself, on behalf of himself and the co-chairperson, so an affidavit of 5th February 2021 to state that the Building Bridges to a United Kenya was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other roles. That the task force and the Secretariat conducted a robust nationwide public engagement and collection of views, and that from these views, it made various legislative, policy, and constitutional amendment proposals in various fields affecting Kenyans. So that although the Secretariat does not disclose its origin, its ancestry, its family tree, its gene cannot be concealed. The affidavit says it all. The great-grandfather is the handshake, the grandfather is the task force, its father is the steering committee, and the surname of all of them is Building Bridges Initiative, alias BBI. The bill which the Secretariat presented together with the signatures to the IEBC was clearly, so to speak, inherited from the steering committee, almost a replica of the bill annexed to the steering committee's report to the President. The draft bill was curiously signed by Building Bridges Initiative as the promoters, and not Honorable Waweru or Honorable Junet, or even the Secretariat. It's not clear how they went about collecting the signatures, but on record, at least, there is some evidence of state involvement, going by the letter written by the Principal Secretary, State Department for Sports, directing the Director General, Sports Kenya, to supervise the staff in the organization to complete the forms and sign appropriately and urgently the forms. The conclusion I reach should be apparent on the first limb of this ground is that the President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the two co-chairpersons when it was too late in the day and beyond recall, that the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances, that he cannot act as an ordinary citizen because he is not, and at the same time claim to be exercising executive authority. He cannot, in the circumstances of Chapter 16, run with the hare and hunt with the hounds. It has been argued that by barring the President from initiating the process of constitutional amendment, his right to equality and freedom from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking the President to stay on his lane of constitutional amendment process. Similarly, the guarantee of his political rights, which are specific under Article 38(1), that is to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referenda, have not been violated. The President's role in the constitutional review process has been preserved and is intact. The power to assent to a draft bill passed by Parliament and to request the IEBC to conduct a national referendum for approval of the bill are indispensable roles and essential cogs in the process. Apart from these, the President, as indeed any other voter, is entitled to support a popular initiative by signing it, and in fact, he did so in public. Indeed, nothing stops the President from campaigning for or against the initiative. For these reasons, I agree with the learned justices that to the extent that the President took certain steps and actions at the inception of the popular initiative process, as explained, the entire process was irredeemably flawed. I would, in the result, affirm the conclusion of the Court of Appeal. The third framed issue is on the second schedule to the draft bill. The number of constituencies today, by dint of Article 89(1), stands at 290. The superior courts below were unanimous and I am in agreement with them, that Article 89 is amendable in accordance with Chapter 16 to increase or even decrease the number of constituencies as proposed. The quarrel with the second schedule relates to paragraphs 1, 2, and 3 of the draft bill. After delimiting the constituencies for the National Assembly to 360, an additional 70 constituencies, the schedule sets out the manner and the period of review of the names and boundaries of those constituencies. This task, in terms of the Constitution, is donated to the IBC, the period being at intervals of not less than 8 years and not more than 12 years, but on condition that any review must be completed at least 12 months before a general election of members of parliament. Furthermore, if a general election is to be held within 12 months after the completion of a review, the new boundaries cannot be used in that election. The second schedule went against Article 89 and all that I've said by providing only for a single criterion, the population quota, as the basis for delimitation. It went ahead and distributed the newly created 70 constituencies to specific counties. It directed the IBC to delimit the boundaries on the new constituencies on the single criterion. It ignored the irreducible constitutional consideration and the existing scientific criteria in Article 89. And finally, it ignored the principle of public participation. In view of the foregoing, the inescapable conclusion is that I'm in respectful agreement with the learned justices of the Court of Appeal that the second schedule to the bill was inconsistent with the Constitution, to which extent it was correctly so declared. I would reject this ground of appeal. The fourth issue is on presidential immunity. In his petition, Force 26 of 2020, Isaac Alochier versus Uhuru Muigai Kenyatta, Mr. Alochier asked the court to determine whether the president can lawfully initiate a constitutional amendment through a popular initiative process, whether the president can establish a steering committee, and whether the steering committee had locus standi to promote constitutional changes pursuant to Article 257. It also sought from the court to determine whether civil court proceedings can be instituted against the president during the tenure of office in respect of anything done or not done in excess of powers donated by the Constitution. Before us, while highlighting his submissions, Mr. Alochier complained that the two superior courts below made pronouncements that were wider than his original prayers, where he had only sought a declaration that the president had acted outside the functions of his office by unlawfully establishing the steering committee, for which he ought to have been held liable. The Court of Appeal, having arrived at the conclusion that the president was not heard in his defense on allegations of breaching Chapter 6 of the Constitution, it was moot to consider whether the president was properly sued in his personal capacity, all the orders made against him in that capacity having been set aside. Consider, too, that both courts nullified the popular initiative on the ground that the president was not qualified qua president to initiate it, confirming that his actions, the gazette notices and so on, were official. Mr. Alochier's question was effectively answered, that no civil proceedings could be instituted against the president in his personal capacity in respect of his role in the proposed amendment. That would have been sufficient to conclude this ground. I cannot agree more that the route taken by the High Court and the Court of Appeal in responding to Mr. Luchier's contention was respectfully slightly overboard. Their determination of the matter in the manner they did has, however, presented a chance to this court to express itself directly on the question for the first time. Under Article 131 of the Constitution, the people of Kenya acknowledge the immensity and enormity of the office, and declared that the President shall not hold any other state or public office except that of the President. Again, because of the exacting nature of those responsibilities, the Constitution grants the President immunity to enable him or her to discharge the functions enumerated above with as much freedom, flexibility, and peace of mind as possible. Because the President's actions while in office are actions of the state and not personal, any person who is aggrieved by the exercise of state power by the President has a recourse. First, to challenge the action in court by naming the Attorney General as a respondent in a judicial review application or a constitutional reference. Or secondly, to institute civil action at the end of the President's tenure, because Article 143.3 holds the time from running for the wrongful actions committed while in office until the President leaves office. And of course, there is the option of impeachment motion, which may be moved in Parliament against the President for engaging in gross violation of the Constitution or of the law, or committing a crime under national or international law, or for gross misconduct. The Court of Appeal fell into error in the manner it construed Article 143 of the Constitution, and for these reasons, I would set aside the judgment of the Court of Appeal to the extent explained. The fifth issue was the place of public participation. The twin questions before us are specific. The place of public participation under Article 10 in relation to the role of IEBC and Article 257(4) of the Constitution, and whether there was public participation generally in respect of the draft bill. Public participation today is a constitutional imperative, recognized as one of the principles of good governance and accountability. A reading of Article 257(4), the role of IEBC is to verify that the initiative is supported by at least 1 million registered voters upon receipt of the draft bill and the 1 million signatures. I've already, in the previous paragraphs, found, in agreement with the two courts in respect of the delimitation of constituencies, that there was no public participation. However, in respect of Article 257(4), the role of IEBC does not extend beyond verification that the initiative is supported by at least 1 million registered voters, without going behind the process to inquire if the promoters did conduct public participation. It is the duty of the promoters to carry out public participation before or as they collect signatures. On their own volition and initiative, the promoters make a proposal to amend the Constitution. They must persuade 1 million Kenyans to vote in support of their venture, to convince the assemblies and parliament about the prospects of the initiative, and ultimately Kenyans in a national referendum. It is the promoter's burden. Was there public participation by the promoters and later by the assemblies and parliament? According to the Secretariat, according to the steering committee, both houses of parliament, some county assemblies, Honorable Odinga, there was public participation prior to and in the course of signature collection. Whether or not there was public participation is a matter of evidence. The burden of proof is always upon him who affirms and not on the one who denies. The burden was upon those who allege that there was no public participation to prove that assertion. Not a single person was presented to support the statement and to rebut the evidence in support of public participation. In support of public participation at the two levels, that is the promoters on the one hand, county assemblies and parliament on the other, there was sufficient evidence. For these reasons, I would set aside the determination of the Court of Appeal on the question of public participation. The sixth issue is on the composition and quorum of IEBC. And it is a common factor that IEBC was not fully constituted when the bill and the signatures were presented to it. Not fully constituted in the sense that it did not have its full complement. The vacancy started with the departure of Commissioner Akombe, who fled the country and announced her resignation while abroad on 18th October 2017, 16th April 2018. Commissioners Mwachanya, Dr. Kibiwot Kurgat, and Consolata Nkatha, who was the vice chair, held a press conference at which they announced their immediate resignation. By a Gazette notice of 14th April 2021, the President formally declared the four vacancies. The vacancies were not filled until September 2021, nearly 4 years from the date of those resignations, and 1 month after the decision of the Court of Appeal in this very matter. Article 250 of the Constitution is what may be called a provision of general application for the reason that it applies to all the Chapter 15 commissions. It declares that each commission shall consist of at least 3 members, but not more than 9. Section 5 of the IEBC Act has fixed the membership at 7, the chairperson and 6 members. For the conduct and regulation of business and affairs of IEBC, Section 8 of the Act refers to the second schedule, which at paragraph 5 provides for a quorum of 5 members. I've discussed in my main judgment the amendments in 2017 to this paragraph, how it was challenged in the case of Katiba, and the decision of Mwita J. I have also considered the effect of the decision in Isaiah Kibiwot Kangwen case, considered too the CKRC report on the management of elections, the Hansard recording the debate on the Election Laws Amendment Bill 2017. I have taken into consideration international best practices and borne in mind that IEBC is a body corporate with perpetual succession. The IEBC, whether fully constituted at 7 members or with the minimum number of 3, is responsible for the formulation of policy and strategy, as well as providing oversight. The Secretariat and supporting units, directorates, divisions, and committees, being the professional and technical arm of the IEBC, perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the commissioners. It is therefore a contradiction of terms for the Court of Appeal and the High Court to say in the same breath that the IEBC was properly constituted with 3 commissioners but lacked quorum to transact business and conduct its affairs. I arrive at the conclusion that with 3 commissioners, the IEBC was properly constituted, quorate, and competent to carry out all its constitutional and statutory duties. In the result, I would set aside the conclusion by the Court of Appeal that the IEBC lacked the necessary quorum to conduct any of its business under Article 257 of the Constitution. The final framed question is on the referendum question. Whether Article 257(10) of the Constitution requires that proposed amendments to the Constitution be submitted as separate and distinct referendum question was raised by Mr. Murara. Again, the details of my analysis of this issue is contained in my judgment, where I have explained in conclusion why I think the issue was premature. Noting that the draft bill had not been returned to the IEBC from Parliament, IEBC had been restrained by an order of injunction from facilitating and submitting the draft bill to a referendum or taking any further action to advance it. The nature of a question or questions to be framed by the IEBC was not ripe. In the end, the Court of Appeal erred in failing to set aside the determination of the High Court on this issue for violating the doctrine of ripeness. I would set aside the majority decision of the Court of Appeal to the effect that Article 257(10) of the Constitution requires the specific proposed amendments of the Constitution to be framed as question or questions. The details of what I've just rendered is in my main judgment. I thank you, Judge President.
Thank you, Justice Ohuko, for rendering your opinion. I will now call upon the Honorable Mr. Justice Renaura to read his opinion.
Thank you, Chief Justice, colleagues and counsel. My judgment is 149 pages. I will greatly summarize it for purposes of this delivery. And there's a presumption that all counsel can read. So please do read it, because other teachers of law tell me that counsel hardly read judgments these days. Please try and read these ones. 2, I have read the judgment of the Chief Justice and President of this court, and I will adapt it for purposes of my judgment. I also agree with the reasoning and findings, save where I shall express myself to the contrary. In that context, when the Kenyan people gave themselves the Constitution 2010, it was a matter of public knowledge that certain parts of it would require amendments at some point in the future. There was, however, no agreement as to what these parts were, and it was left to a political class to raise a number of issues over the years that debatably required amendment. Third Way Alliance, for example, initiated the Punguza Mizigo, Lighten the Burden initiative at a referendum on a number of issues. That initiative failed. I have therefore taken into account the pleadings, the submissions, and my opinion on each issue is summarized as follows. On issue number 1, I delved into the history, the genesis and history of the basic structure doctrine. Like my colleagues before me, I looked at Kesavananda at length and the history of Kesavananda and the findings in Kesavananda. I also delved in the history of Article 257 on amendments through a popular initiative as opposed to legislative amendment under Article 256. I specifically looked through the CKRC reports, and in the final report, I reproduced sections, page 75, where the Commission said this: a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions, which should include supremacy of the Constitution, the Bill of Rights, land, the judiciary, security, finance, and the system of government. The final report then came up with the following recommendations. I'll only pick on 2. Recommendation number A: the new Constitution should have some entrenched provisions, for example, human rights, that Parliament does not have power to amend. And Roman D2, the entrenched provisions should include the procedure on amending the Constitution itself, the provisions establishing the Republic of Kenya, the provisions of sovereignty of the people, the provisions on supremacy of the Constitution, the Bill of Rights, the separation of powers, provisions on existence and powers of independent commissions and bodies. Those proposals by CKRC are important because, like Professor Migai Akech, amicus curiae, I have said that the above recommendations are what morphed into Chapter 16 of the 2010 Constitution, and by those provisions, the people attained the right balance between constitutional flexibility and rigidity and provided sufficient and strong safeguards against the culture of hyper-amendability that characterized the Independence Constitution. Chapter 19, in fact, of the BAMBA draft and Chapter 19 of the WACO draft are also identical as to what's contained in Chapter 16 of the Constitution today. History has shown us that the people did not intend to immunize the 2010 Constitution. To the contrary, they envisioned that they could amend the provisions of that Constitution through exercise of secondary constituent power, provided that the amendment procedure under Chapter 16 is strictly observed. If the people wanted to entrench provisions other than those set out under Article 255(1) or to immunize any of the provisions of the Constitution, they would have done so expressly. It is therefore correct to say that courts should not, by judicial craft or innovation, impose hurdles to prevent the people from amending the Constitution, provided that procedural requirements under Chapter 16 are complied with. In my judgment, I made reference to my own decision in Commission for the Implementation of the Constitution versus the National Assembly of Kenya and two others. I had counsel in this court say that that was the introduction of the basic structure doctrine by courts in Kenya. That is not anything near the truth. That judgment was addressing amendments by Parliament to Article 260 of the Constitution in order to remove the offices of members of Parliament, members of county assemblies, judges and magistrates from the list of designated staff officers under that article. The dispute, much like Kesavananda, related to the amendment power donated to Parliament. Maisha, to Singapore, to Israel. And I have said in my judgment that each country has taken a different approach on the basic structure doctrine because each country has its unique circumstances and we must do the same. I've also looked at the Njoya case and I've explained why the Njoya case, the circumstance it was made, the context in which it was made, and the reason why the Njoya case cannot be relevant in processes under Article 257. And going to the four sequential steps, I've said those processes are indeed relevant and useful, not in amendment under Chapter 16, but making of the Constitution, should we as a country ever decide again to do away with the present constitutional order and create a new one. And therefore, in summary, on issue number one, my finding is that the basic structure doctrine does not apply in Kenya in the manner suggested by the first, the fifth respondents, and that the four sequential steps set out by the High Court and the majority of the Court of Appeal only apply when a new constitution is being made and not in any amendment process under Article 257. In addition, based on our history, the text of our Constitution, and the context as outlined in my judgment, it is legislation such as the CKRC Act 2008 and 1997 that the four sequential steps should be anchored when and if the people ever want to change the present constitutional order. Those are my findings on issue number one. On issue number two, I have read the Chief Justice's judgment. I have looked into the history of Article 257. And if you look at the CKRC reports, Article 257 was intended to be exercised by the common man and civil society. and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like George J.A., I'm certain that popular initiative is people-centric, and while the President has certain rights as a citizen, there are certain other things that are curtailed by the Constitution as regards him. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill and then retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 256(5)(a) and then under B, request the IEC conduct within 90 days a national referendum for approval of the bill and then retire to assent to it as a President. And therefore, my finding is that he cannot initiate a popular amendment under Article 255. But I've said, knowing the politics of this country, if the President has parliamentary muscle, he can then invoke Article 256 and initiate amendments through Parliament. On the second limb of this question, I have disagreed with my colleagues. My finding is that there are two processes involved in this whole situation. The first process is the presidential political process, which ends with the creation of the steering committee. And then there is the process under 257(1), which is the process of the secretariat led by Junet Mohammed and Dennis Waweru. And I've said that if you look at 257 properly, the process begins with the signature collection and creation, and the drafting of the bill or suggestion. And that process was only undertaken by Dennis Waweru and Junet Mohammed, and there is no place in which I have found in the record the role of the President. And therefore, on that narrow issue, I have disagreed with the Chief Justice. On the second schedule of the Constitution of Kenya, whether it's unconstitutional, I have looked at Article 89(1), and I have said you cannot, as that was done by the initiators and promoters, purport to amend Article 89(1), leave Article 89(2) to Article 89(12) untouched, and then purport to bring this amendment bill and create new constituencies without involvement of the IEBC and the people, especially those who will be affected by the creation of new constituencies. Boundaries of constituencies are a very emotive question in Kenya, and that is precisely why Section 89 is very elaborate as to the procedure to be undertaken when new constituencies are being created. And therefore, for those reasons, and for the reasons given by the Chief Justice, I've agreed that that schedule is unconstitutional. But I've said something a little more. Let those who wish to create new constituencies follow the process under 89. Do not ignore IEBC, don't ignore the people, and if you wish to start the process within Section 89, Article 89, you are permitted to do that, but do not go outside the remit and permits of Article 89. That takes me to issue number 4, proceedings against the President. I agree with the Chief Justice on this question, and I've also addressed the remedy of impeachment of the President should there be a violation of the Constitution. I've also addressed my judgment in the High Court in the Isaac Aluochir case on representation of the President by the Attorney General when the President is sued in his personal name. I have said that the President cannot be sued in his personal name for violations of the Constitution, and should he be sued for whatever reason, then the proper respondent should be the Attorney General and not the President in his personal capacity. I had lawyers for the President pray for costs in favor of the President for having been properly sued in his private capacity in this case. While I agree with them that such an order would have been efficacious, in fact, the nature of this particular litigation being in the public interest, I would not grant the President orders of costs, despite my findings in his favor. On issue number 5, public participation by the IEBC and the initiators and promoters of the bill, I have looked at the BAT case, a recent decision of this court. I've also looked at Justice Pauline Nyamoya's judgment in Republic versus County Assembly of Kirinyaga, and I've agreed with the judge that in processes under 257, there are certain rules attributed both to IEBC and to the initiators and promoters. Looking at the stage at which the IEBC was stopped or the whole process was stopped, it is very difficult for me to say that public participation was not sufficient. In fact, the two most important public participation elements in a popular initiative are voter education by IEBC and popularization of the bill by the promoters. None of these processes had been reached by the time the High Court stopped the process. A last issue on this point is this. Gatembo Kairu and Tuyot raised a fundamental question. Why are we as a country still struggling with lack of a legal framework to govern processes under Article 257? There is no law on collection of signatures. There is no law verification of those signatures. There is no law on how county assemblies should pass the amendment bill, the processes by parliament despite the standing orders, the receipt of the bill by the president, transmission of the bill to the president, the referendum. I have said it is about time to avoid the confusion that I'll address shortly as address issue number 6 and 7, that we need a law. And so I agree with Justice Tuyot and Justice Kairu that this law is absolutely necessary. And therefore, the second schedule, in my mind, is an exception. The public participation processes were properly undertaken, save for the second schedule, where I have said that it's unconstitutional for the reasons that I've given. Articles 88 and 250 with regard to composition and quorum of the IEBC. I have looked in my judgment at the Katiba case by Chacha Mwita J. I have looked at the Isaiah Biwott case by Frida Okwan J. I have looked at Article 250, sub-Article 1. I have taken into account the very lucid submissions by Esther Angawa regarding Article 88.5, and I have said that, to my mind, looking at the law as I understand it, IEBC was correct at all material times, its processes were lawful, and therefore a contrary finding would, in my view, be in error. There was a second issue raised by Ms. Kituku regarding nullification of the laws. Well argued as the point was and lucid as arguments were, I've declined the invitation to address that question because once I found IEBC correct, other matters are irrelevant. The last issue is issue number 7 on the proposals, whether proposed amendments should be submitted as separate and distinct referendum questions. Like the Chief Justice, I have looked at the law of ripeness and mootness. I have looked at the law on justiciability, and I have come to the firm conclusion, like Justice Tuyot, that this question was premature. IEBC had not had the opportunity to exercise its mandate as the body to conduct the referendum, to draft the question or questions, and I've said only this as regards that mandate. Section 49 of the Elections Act and Article 257 do not sit well together. And I've asked IEBC, as they reconsider this question, to look at Section 49 of the Act and Article 257, harmonize the language. I've shown why, in my judgment, why there's a problem with that issue. And only then would any party with a dispute go to court once the IEBC has determined the matter within its mandate. Once courts start taking off the mandate of independent commissions, we shall walk into a minefield. And therefore, in conclusion, summary of my findings are as follows. On the basic structure is my finding that the doctrine as enunciated in the Savanada case has not attained wide acceptability and cannot certainly be applicable to Kenya, noting our history, context, and constitutional text. The 4 sequential steps identified by the High Court as necessary in an amendment process are also not applicable, save in the creation of a new constitutional order, which is not the case in this dispute. Number 2, on whether the President can initiate a popular initiative to amend the Constitution Article 257, it is my finding that he cannot, but I've said also that in this particular dispute, he did not. On whether the second schedule of the Constitution is unconstitutional and purported to limit boundaries without the input of IEBC, without amending Article 89, 1 to 12, without involving affected persons and the public at large, I have held that is indeed unconstitutional. Can civil proceedings be instituted against the President during the term of office? I have said no. And should he be sued, then the proceedings should be against the Attorney General, and any remedy for a suit directly against the President should lie in costs awardable to the President. more public participation. At the time the High Court stopped the process, I cannot find reason to fault either IEBC or the initiators and promoters, with the exception of the second schedule, which I found to be unconstitutional for inter alia lack of public participation. On the quorum of IEBC at all material times, I find that IEBC was correct and all its undertakings were lawful. On the question whether a referendum, single multiple questions should put the people by IEBC, I find the matter was premature and was not ripe for determination. On costs, the public interest exhibited in this matter lead me to the conclusion that each party should bear its cost. My reasons in detail are contained in my judgment, which you shall get copies of. I thank you, Chief Justice. I thank you, Counsel.
Thank you, Honorable Mr. Justice Renaura, for rendering your opinion. I will now call upon Lady Justice Jokindongo to deliver her opinion.
Thank you very much, Chief Justice. I will proceed to summarize my judgment. On some issues I will be brief, others I will interrogate them a little bit more. Issue number one, is the basic structure doctrine applicable in Kenya? In order to determine whether the basic structure doctrine is applicable in Kenya, there is need to define the term doctrine under international law and establish whether the basic structure doctrine is indeed such a doctrine and if it is applicable here. I recognize that there are differing opinions on the definition of a legal doctrine, but to my mind, the basic structure doctrine as presented by the parties to us is a judge-made law emanating from the municipal court, which is the Supreme Court in India, in the Kesavananda case. That basic structure doctrine has been upheld and relied on in subsequent decisions in India, and I note that there are few jurisdictions around the world where basic structure doctrine has been applied, while in others it has been rejected. It is my considered view that the basic structure doctrine as presented by the parties does not constitute a widely adhered to a legal doctrine. It is my observation that the basic structure doctrine has been both applied and rejected. I have listed the countries in which that has happened, and therefore it is my considered opinion that the states only constitute a very small percentage of countries in the world that have attempted to apply or have applied the doctrine. Furthermore, there have been no pronouncements made at the international level, no international case law on the same. The only available cases are from domestic courts at national jurisdiction, and therefore it cannot be said that the basic structure doctrine has attained the status of a general principle under international law, and it cannot be applied by this court as a general rule of international law as contemplated on Article 2(5) of the Constitution of Kenya 10. The above notwithstanding, is the basic structure doctrine as presented by the parties applicable in Kenya? It is my considered opinion the answer to this question can only be deduced by our constitutional past. Kenyans stressed the fact that they needed a constitution that had entrenched provisions on certain aspects, was not too simple to amend, and one that required their participation in terms of amendment. The final report of the Constitution of Kenya Review Commission captures these sentiments where the people's voice is summarized. And these sentiments made it into our current constitution, where Chapter 16 of the Constitution is unequivocal on how to amend the Constitution. It is therefore my position that it was the intention of the drafters of the Constitution to protect or entrench the specified 10 matters in Article 255(1) by stipulating their specific amendment procedures. If the drafters of the Constitution intended to entrench or protect any other provisions or deem them eternal or unamendable, they would have expressly done so. On my part, I do not consider any article in the Constitution unamendable or constituting eternity clauses. A textual reading of the Constitution confirms this view. It is evident, therefore, that the Constitution itself expressly provides an inbuilt amendment procedure for any anticipated amendments. Consequently, it is unnecessary to import the so-called basic structure doctrine into Kenya. I briefly turn to the issue of constituent power. And I find that the constitutional power is a power that cannot be limited by any pre-existing rules, even if such rules purport to regulate replacement of the current constitution. It is also my finding that the 4 sequential steps are not expressly provided for and cannot be inferred from Article 257 of the Constitution. As such, those steps cannot be a mandatory requirement when there is no law providing for the same. Moving on to the next issue, as to whether the President can initiate changes or amendments to the Constitution. The Court of Appeal upheld the High Court's finding that the President, for as long as he held office, could not, as an ordinary citizen, move constitutional amendments through a popular initiative on the ground that the same route is intended for ordinary citizens. The appellate judges found that the amendment bill was not a popular initiative, considering that the process that culminated in the same was a process that was led and driven by the executive, the political elite, as opposed to the people of Kenya. Some respondents have urged that the proposals by the BBI task force could have been taken up by anyone else, by any promoter, but not the President himself. Having perused carefully through the judgments of the Superior Courts and also through the Constitution of Kenya, I find this proposition is untenable for several reasons which I shall expound upon. However, before I expound on my views, I must state I'm rather disturbed and concerned by the way the Superior Courts framed their issues for determination. The High Court framed its issue 3 for determination and used words not in the constitutional text, attached meaning to them, and made determination on them. At paragraph 388 of its judgment, the High Court framed the issue as follows. What is the constitutional remit of amendment of the Constitution through a popular initiative? This issue further twins into 2 sub-issues. Who can initiate a popular initiative under our constitutional setup? And 2, the BBI process, is the BBI process of initiating amendments to the Constitution in conformity with the legal and constitutional requirements? And 5, was the President in contravention of Article 73(1) of the Constitution for claiming authority and purporting to initiate constitutional changes through BBI? Similarly, at the Court of Appeal, Musinga, President of the Court of Appeal, listed the following issue for determination: whether the President of Kenya can initiate the process of amendment of the Constitution as a popular initiative, and who the initiators and the promoters of BBI initiative were. The learned judges of appeal unanimously agreed with the High Court that the BBI amendment process under Article 257 of the Constitution was intended for ordinary citizens. Further, they stated that this is a citizen-conceived, citizen-initiated, and citizen-driven process. A lot of time and attention was dedicated to the meaning of certain words. This would not be problematic if these words were found within the body of the Constitution to interpret an appropriate meaning to them. However, interpretation of words not in the Constitution bring confusion. In my view, a constitutional court must confine itself to interpretation of the letter of the Constitution, and if any word or phrase is read in, it must be clear that this is the rule of interpretation at play. The words I'm concerned about include initiate and initiator, citizen initiated, and private citizen. None of these words appear in Articles 255 to 257 of the Constitution. The High Court in particular went on a spirited approach to expound on these terms and paid little attention to the words that actually appear in Chapter 16 of the Constitution, which are the words promoter, popular, and initiative. In my opinion, the learned judges introduced a non-constitutional actor called an initiator, who performs a non-constitutional action, initiate, when the Constitution only provides for a promoter whose definition is vastly different from an initiator. As such, the emphasis was laid on the actor-initiator. This, in my opinion, fundamentally changed the import and meaning of Article 257 of the Constitution, and I am of the opinion that the correct approach should have been to define what a popular initiative is and who can be or who is a promoter of a popular initiative. The Superior Courts ignored the fact that the drafters of the Constitution used certain words and went in to read in words whose effect is to change the entire meaning of the constitutional text. The tool of reading in is only applied where the framers have left out a word or phrase from a provision. Further, this reading in must be supported by other connected provisions of the Constitution. I perused carefully all the judgments, looking for proper reasons for the decision to exclude the President from the amendment process, and I cannot find a logical, constitutionally based explanation for the conclusions and findings of the superior courts on this question. I can only term it as interpretational misadventure, if not judicial constitutional overreach or judicial invention. As such, the learned judges erred fundamentally on this, and in my considered view, which I shall now expound on, I will specifically look at the constitutional amendment process as provided for in Chapter 16, the interpretation of constitutional silences, the exercise of the authority of the people under Article 1, the authority of the President under Article 131 and 132 and 141(3), and the political rights under Article 38. The Constitution 2010 provides for two processes through which it can be amended. These are the parliamentary initiative and the popular initiative. For the popular initiative, promoters, after collecting the signatures of at least 1 million voters, submit the signatures and the bill to IBC, who sends the bill to the counties. The bill must then be approved by a majority of the county assemblies, and then approved by a majority of the Houses of Parliament. And if Parliament passes the bill, it is submitted to the President for assent. It then goes to referendum where the majority of voters must support it. Article 257 does not define popular initiative. Nevertheless, I am of the opinion that at the heart of construing the meaning of popular initiative, it lies with the numbers. It is proper to lay emphasis on the numerical value of at least 1 million registered voters who have to sign, the numerical value of at least half of the counties who have to vote to support, the numerical value of 2/3 of the votes in both houses in Parliament, and the numerical value of half the votes cast by registered voters at the referendum. It is the numbers that count. It is the numbers threshold that the promoter must meet. It is the numbers that makes the initiative popular. In the context of Article 257 of the Constitution, a promoter needs at least 1 million registered voters to support their proposals. That's what triggers the IEBC verification process. It is therefore my considered view that the popular initiative is primarily about numbers that the promoter must attain, and not about who the promoter is or who the person who brings the amendment is. As such, the Superior Courts made a fundamental error by determining that popular, the word popular, relates to who moves the amendment and not the numerical threshold that the promoter has to attain. So, for example, in 2016, the COA Kenya bill were not able to achieve the 1 million signatures, and it collapsed through the operation of the law. It is important to note also that Section 257 does not in any way specify who may move a constitutional amendment process by popular initiative. It does not contain an explicit bar against any person promoting a constitutional amendment by popular initiative. It specifically provides what actions the promoters are tasked with in order to begin and complete an amendment process, but it does not state who the promoters must be. The unsaid is influential in constitutional law. Some matters of constitutional relevance sometimes are left unaddressed. Sometimes, knowingly or unknowingly, the drafters of the Constitution may underappreciate how much power rests in the silence around the text. Constitutional silences are functional and inevitable, and enabled by a lack of very strict textual restraints, constitutions have the capacity to grow with time, experience, societal needs and changes, thus allowing successful constitutions to thrive. This Supreme Court has played a crucial role in interpreting silences in the Constitution, but it must be cautious, though, so as to avoid judicial legislation. This court must interpret silences judiciously. Taking recourse to this doctrine, therefore, how do we interpret the silence as to who can originate a popular initiative amendment. In my considered view, the first step leads us directly to the constitutional text itself. Article 1 of the Constitution is categorical, that all sovereign power belongs to the people of Kenya and shall be exercised in accordance with the Constitution. Further, in that article, sovereign power may be exercised either directly or through their democratic elected representatives. The National Executive enjoys delegated sovereign power under Clause 3 of Article 1 of the Constitution, and according to Article 36(1) of the Constitution, the President shall be elected by registered voters in a national election conducted in accordance with the Constitution. In addition, Article 1 of the Constitution elaborates the tenets of a functioning republic, anchored in the concept of libertas populi, which defines the characteristics